This is probably best explained by using another case study. If we go back to Luke and Sarah's case study, let's assume Sarah did have a TT will at the time of her death. Because Sarah owned her home jointly with Luke and her share of the home automatically passed to him, everything else though, including her super and life insurance, passed into the trust set up in her will for the benefit of Luke and Sarah's biological children. At the time Sarah set up her will, she trusted her husband Luke implicitly and decided that he should be in complete sole control of the trust. Sarah trusted that Luke would do the right thing and use the money invested in the trust to look after himself and, importantly, her children. Because Luke is in sole control of the trust, the assets inside of the trust will look and feel like his assets. Luke will literally be able to log in to online banking using an app on his phone and manage the trust bank account exactly like his personal bank accounts. He could pull out lump sums, he could take the kids to Disneyland, he could buy new assets, pay off his mortgage, or use the money in the trust to refinance. If you've ever been a director of a company and you've had a company bank account, you'll know what I'm talking about. The setup is pretty similar. Let's assume Luke eventually repartners and they break up. The trust ensures there is this great big separation, like a firewall, between the assets in Sarah's trusts and Luke's personally owned assets that are going to be on the table and available to the second ex in any divorce or separation proceedings. Now, I'm not suggesting the trust is entirely bulletproof, but it definitely will be so much harder for that second ex to claim that the assets in Sarah's trust should be her property. Because Sarah had a TT, Luke has a 100-meter head start protecting the assets compared to if Sarah didn't have a TT at all. Now, if Sarah had any inkling that Luke would repartner after her death and she was really worried he wouldn't manage the trust properly to look after her children, Sarah could appoint another person to work alongside Luke to act as a bit of a check and balance. There are pros and cons of having more than one person in control of a trust. One benefit is it really beefs up the asset protection of the trust because it becomes a lot harder for a creditor or a predator to argue that the trust is some kind of sham arrangement and the assets inside of that trust are really just Luke's, since he can deal with the trust assets without some other controller's knowledge and approval. On the downside, we can enter into costly dispute territory if there is a deadlock between two controllers. So if you want to really lock down the trust and restrict it, you need to appoint controllers that can work together, or alternatively, appoint an independent controller like an accountant or a trusted friend. Now let's assume Luke and Sarah prepared their wills in their 70s and they're not concerned about the survivor repartnering. So they decide in their wills that the trust should only come into operation on the survivor's death, that is, when they're both not here. In this instance, the trust or the trusts will be set up for the benefit of their children only. Again, it's a flexibility versus risk balancing exercise. If they trust their kids to manage their trusts on their own and they're not concerned about their kids' relationships breaking down and their in-law children running off with their legacy, then they might keep it simple and flexible and allow each child to be the controller and the beneficiary of their own trusts. As I've explained in the other videos, this will mean the assets inside the trust will look and feel like that particular child's assets. The child will literally be able to log on to online banking using an app on their phone and manage the trust bank account exactly like their personal bank account. They can pull out lump sums, take their kids to Disneyland, buy new assets, pay off their mortgages, all without having to get the approval from anyone else. If Luke and Sarah, however, were worried about their kids' relationships or their high-risk occupations, then they could appoint a trusted sibling to be the co-controller of the trust or a combination of their children. They would need to be mindful, of course, about entering into dispute territory and causing a rift between their children. And it may be the case that they need to consider appointing a trusted friend or an independent like an accountant, to control the trust. Now, the next big decision is who do Luke and Sarah select as backups to cover the scenario of their first choices being unable or unwilling to be the controller of the trust. This could be due to death, incapacity, or bankruptcy. Having a succession plan for the role of controller is an equally important decision. In summary, what I really want to reinforce is that choosing a controller is an intricate balancing exercise between flexibility and your appetite for risk, and the person or the people you nominate to control your trusts will be unique, as every family is different.